Hello, everyone. My name is Teresa McClenahan, Executive Director and Counsel at the Canadian Environmental Law Association. Thank you for joining us for this episode of Walkerton's Drinking Water Protection Legacy. In this series, we commemorate the 20th anniversary of the contamination of Walkerton's water supply by speaking with the people who experienced the tragedy and the inquiry that followed firsthand. With me today is Richard Lindgren, who is Senior Counsel at CELA and was one of the lawyers representing the concerned Walkerton citizens at the public inquiry, digging into the direct and systemic causes of contamination of the town's water supply. Rick has been at CELA for over 30 years, representing CELA clients across Ontario, and holds degrees in history and law from Queen's University. Rick, thanks for joining me today.
Good morning.
So when you were representing the concerned Walkerton citizens at the Walkerton Inquiry following those tragic events in May 2000, the town's drinking water had been contaminated. What were some of the things you focused on?
Well, we split the case up between the four lawyers at CELA, and each of us took on different issues and different evidence. I tended to focus on the physical cause of the contamination at Well 5 in the town of Walkerton. I also tried to address some of the larger systemic issues, such as the need for timely emergency declarations and the need to set and enforce stringent provincial regulations with respect to drinking water safety.
And why do you think it was important for CELA to represent the concerned Walkerton citizens at the inquiry? What value do you think we added?
Well, prior to the Walkerton tragedy, CELA had a long and extensive history of involvement in drinking water safety. For example, a lot of our casework tended to involve groundwater or surface water protection. In addition, CELA had been pushing for specialized drinking water legislation in this province for about 2 decades prior to the Walkerton tragedy. So I would say, in light of that experience, in light of that expertise and knowledge, I think it was a good fit for CELA to represent the citizens of Walkerton at the public inquiry. I would add that we had a common objective that we shared with the residents of Walkerton. That is, we wanted to get to the bottom of things. We wanted to find out exactly why this tragedy occurred. And more importantly, we wanted to find out what steps would be needed in order to prevent the recurrence of a tragedy like what occurred in Walkerton in 2000.
And I can remember actually meeting with Commission Counsel in our CELA boardroom the summer before the inquiry started to speak to them about some of those issues that they might want to investigate and documents they might want to take a look at as they framed their approach to the inquiry.
Well, that's right. I think we had good early interventions in the shaping of the process to make sure that it was thorough, it was comprehensive, and that some of the larger systemic issues were not shunted aside or ignored or glossed over. And to the credit of the inquiry, the commissioner and the staff delved quite deeply into those issues. And I think we're all pretty happy with the result.
And we, on behalf of the citizens, wanted to make sure we knew not just the immediate factual sequence of events, but as you mentioned, those broader systemic issues, and they did end up being very important to how Justice O'Connor shaped his recommendations in the ultimate report. So what are some of the memories you have about what it was like to represent the concerned citizens at the inquiry?
Well, I have to say I was a little shell-shocked when we first moved to Walkerton and lived there for the duration of part 1 of the inquiry. We rented an apartment and it was shared by the 4 lawyers who were at the inquiry from time to time. And just the impact on the day-to-day living of the residents is what really got my attention. I mean, you couldn't trust what was coming out of the tap. You couldn't really wash your hands. You couldn't bathe, couldn't shower, couldn't cook with it, couldn't drink with it. When you don't have drinking water coming out of your tap that you can rely upon, that affects a lot of things. It affects people's homes, it affects businesses, it affects restaurants. I was just astounded that this town was able to persevere despite the daunting challenges of having no potable drinking water in the entire municipal system.
And when you speak about the water in the town, Rick, I clearly remember that once the water was deemed safe to drink, um, Justice O'Connor insisted that that's what was on everybody's tables, was Walkerton Town tap water. Nobody was drinking bottled water at the inquiry. If the people of the town were expected to drink it and trust in the authorities, we were all going to demonstrate that we all trusted it.
That's true. But I think most of all, what I recall is the patience and the resilience of the community itself. I think the town and all of its residents were obviously going through some very, very tough times. Lots of stress, lots of anxiety. You couldn't trust what was coming out of your tap for a good chunk of time. But somehow the people of Walkerton persevered. They got through this crisis and they participated fully in the inquiry. And I think in the end, the people of Walkerton helped contribute to a stronger, more robust framework for protecting drinking water safety in this province.
Mm-hmm. Yeah, and it's interesting when you talk about the cooperation between Commission, Council, and the parties. For example, that was an interesting process for us because we're used to being involved in an adversarial process, and while there was cross-examination of witnesses in this hearing, it was a commission of inquiry, so all the witnesses were the commission's witnesses. And so that meant that we were all trying to aim toward finding the actual causal links, and this was not really intended to be a prosecution or a finding of liability the way it is in some of the other work that lawyers normally do.
Well, that's right. I think it was a well-structured and well-organized inquiry. And keep in mind that the objective was to find the truth, not to decide who's right, who's wrong, who's liable or not. And so I think with those objectives in mind, I think the inquiry did an excellent job.
Right. So thinking about it now, 20 years later, what would be one or two of the most significant results of the inquiry, and what do you hope that we as a society remember going forward?
Well, I tend to draw three lessons learned from the Walkerton inquiry. I think the first and most important one is that a multi-barrier approach is absolutely key if we're serious about protecting drinking water for the residents of Ontario. I think a related second point is that we can't be complacent about drinking water safety. We can't take drinking water quality for granted. We have to be constantly vigilant at all material times to make sure that people are doing their jobs and that drinking water is safely protected, because the consequences are pretty devastating if we don't. I think the third and final lesson is that deregulation is a really risky agenda. I think we saw firsthand the effects of an overambitious attempt to cut so-called red tape by the provincial government at the time. And I think we now know that deregulation is dangerous, particularly in the context of drinking water safety, where people's lives and well-being are at risk.
And on that topic of red tape reduction and deregulation, you and I co-authored a piece a year or two in the Toronto Star about that, talking about regulation is not red tape. But it's been an approach of all kinds of governments, provincial and federal, over the past many years, even subsequent to Walkerton. And for example, one of our colleagues in the Lac-Mégantic tragedy found that was a significant cause as well. And now, in the context of the 20th anniversary, we're dealing with a pandemic, a global pandemic. So I think that bears a lot of reflection that, those things that we think are inefficient are actually important for safety if it has to do with redundancy of oversight and, as you say, multiple barriers.
I think that's an excellent point. And the one thing that concerns me a little bit is as we attempt to recover from the current pandemic, there might be a temptation among some governmental decision makers to cut or gut or roll back regulation, all in the hope that it might spur economic development. I think that's a very dangerous path to go down in light of what we've learned at Walkerton. So I'd caution governmental decision makers and policymakers not to go down that path again, because we've seen it's fraught with peril, shall we say.
This interview is one of a short series titled Walkerton's Drinking Water Protection Legacy, curated by CELA, to be housed on the CELA Foundation's environmental history pages. In this series, we focus on the essential lessons learned from one of our significant CELA cases, the Walkerton Inquiry, and how to ensure drinking water protection and environmental protection is safeguarded into the future. Richard Lindgren was co-counsel for the concerned Walkerton citizens. Rick, thank you so much for joining us today.
Thank you, Teresa.